You are not imagining this. In the very heart of the American West, in a state where MAGA influence once seemed absolute, the constitutional ground has just shifted in a way that Washington never anticipated. Today, the Wyoming Supreme Court delivered a 4-1 decision that did more than just strike down a law. It issued a historic verdict on the limits of legislative power in a free society. This isn't just a victory or a defeat for one political side. It is a stress test for the entire idea of state-level democracy. If you thought the battle for the U.S. Constitution was only happening in D.C., you have been looking in the wrong direction. Welcome to the day the red wall of abortion bans met the immovable force of a state constitution. The Wyoming Supreme Court has officially struck down 2 of the most restrictive abortion laws in the country, a total ban on the procedure and a first-of-its-kind ban on medication abortion pills. These laws were the crown jewels of the Wyoming legislature's 2023 session, passed on the heels of the U.S. Supreme Court's Dobbs decision, which many believed gave MAGA-led legislatures a blank check to regulate personal health. However, in a move that has left Republican leadership in disbelief, the court ruled that these bans fundamentally violate the Wyoming Constitution. To understand how we got here, we must look at Article 1, Section 38. Ironically, this provision was added to the state constitution in 2012 by conservative voters who wanted to protect themselves from Obamacare. It states that each competent adult shall have the right to make his or her own healthcare decisions. Now, that very same conservative-backed amendment has become the constitutional shield, protecting reproductive rights. The state's argument, led by the MAGA-red governor, was that abortion is an intentional act of killing, rather than healthcare. But the court, led by Chief Justice Baumgarten, rejected this framing entirely. They noted that if the legislature allows exceptions for the life and health of the mother, it has already admitted that abortion is, by definition, a healthcare decision. This ruling effectively restores first-class citizenship to women in Wyoming, making their rights no longer dependent on the changing whims of a partisan legislature. For the GOP leadership, like Speaker of the House Chip Neiman, the ruling is a moment of total disbelief. But for those analyzing the institutional stability of the West, it is a signal that checks and balances may still be alive in places we least expect them. The fatal flaw for the MAGA-led legislature began when they attempted to redefine the very nature of medicine to fit a political narrative. The state of Wyoming and its governor argued aggressively that abortion is not healthcare, but rather an intentional act of termination that sits outside the realm of medical practice. By attempting to categorize abortion as a non-medical act, the state hoped to bypass Article 1, Section 38 of the Wyoming Constitution, a provision that grants every competent adult the fundamental right to make their own healthcare decisions. However, the Wyoming Supreme Court saw through this legislative maneuver with cold legal precision. The court pointed out a glaring internal contradiction within the very laws the legislature was trying to defend. The statutes included exceptions for the life and health of the mother. If a procedure is deemed necessary to protect the health of a woman, the court reasoned, it is logically impossible to argue that the procedure itself is not health care. This hypocrisy turned the state's own legal language into a weapon against its ban. Beyond the text of the law, the court looked at the grim reality of medical data presented during the case. Statistics provided to the justices, which remained unrebutted by the state, highlighted that mental health decline is a leading cause of death for women related to childbirth. By ignoring these medical realities, the legislature failed to recognize that for many women, the decision to terminate a pregnancy is not a political choice, but a life-saving medical necessity. The court concluded that once a decision is identified as health care, it falls under the protection of the individual, not the state house. Because the right to health care is enshrined as a fundamental right in Wyoming, the court applied the most rigorous legal test available, strict scrutiny. Under this standard, the state bears a heavy burden to prove that its laws are the least restrictive way to achieve a compelling interest. The justices found that the state failed to demonstrate how a total ban on medication or surgical abortion was a reasonable and necessary restriction. In essence, the state tried to play doctor and the Supreme Court ruled that they didn't have the license to do so. This battle over the definition of healthcare represents a profound struggle for individual autonomy. The court's rejection of the legislature's Life Act findings serves as a reminder that constitutional rights are designed to protect the individual from the tyranny of the majority. For the 4-to-1 majority, the decision of whether to continue or terminate a pregnancy is influenced by physical, mental, and financial considerations that are deeply personal and unique to the woman. By striking down these bans, the court has signaled that in Wyoming your medical chart belongs to you, not the government. There is a profound irony at the heart of this ruling that political analysts are calling the conservative boomerang. The very legal weapon used to dismantle the MAGA-led abortion ban was forged by conservatives themselves over a decade ago. In 2012, Wyoming voters overwhelmingly approved Article 1, Section 38 of the state constitution, a provision specifically designed to shield citizens from the perceived overreach of the Affordable Care Act, commonly known as Obamacare. At the time, the goal was to ensure that the government could never force an individual to participate in a federal healthcare system or dictate their medical choices. The text of this amendment is remarkably direct, stating that each competent adult shall have the right to make his or her own healthcare decisions. For years, this was hailed as a landmark victory for individual liberty and limited government in one of the most conservative states in the Union. However, when the Wyoming legislature attempted to implement a near-total ban on abortion and medication pills, they found themselves on a collision course with the very medical freedom language they had championed years prior. During the proceedings, the state of Wyoming and its governor attempted a desperate legal pivot, arguing that the 2012 amendment was never intended to cover abortion. They claimed that abortion sits outside the definition of healthcare entirely, framing it instead as a criminal or moral act. But the Wyoming Supreme Court, led by Chief Justice Baumgarten, delivered a sharp rebuke to this selective interpretation. The court made it clear that they would not defer to the legislature's sudden, politically motivated redefinition of what constitutes medicine. By ruling that the decision to terminate or continue a pregnancy is a fundamental healthcare choice, the court turned a conservative anti-Obamacare measure into a powerful pro-choice tool. This creates a massive problem for MAGA strategists who have spent years embedding health freedom language into state laws to fight federal healthcare regulations. They are now discovering that in a court of law, constitutional protections for individual autonomy cannot be turned on and off based on which medical procedure is being discussed. This boomerang effect serves as a warning for the limits of partisan lawmaking. When a legislature passes a constitutional amendment to serve a short-term political goal, they risk creating a permanent standard that applies to every citizen's most private decisions. In Wyoming, the legacy of the 2012 medical freedom movement has matured into a reality that protects a woman's right to choose, proving that the law is a double-edged sword that can cut through even the most entrenched political agendas. The legal mechanism that ultimately dismantled the state's ban was the application of strict scrutiny, the highest and most demanding standard of judicial review in the American legal system. Once the Wyoming Supreme Court determined that the right to make one's own healthcare decisions is a fundamental constitutional right, the burden of proof shifted entirely away from the citizens and onto the state government. In the world of constitutional law, being subjected to strict scrutiny is often described as strict in theory but fatal in fact for the legislation being challenged. To survive this test, the state had to prove not just that the law was a good idea, but that it served a compelling state interest and was narrowly tailored to achieve that goal without unnecessary infringement on individual liberty. The state argued that its compelling interest was the protection of unborn life. However, Chief Justice Baumgarten and the majority found that the state failed to meet its burden of demonstrating that a total ban was the only way to achieve this without violating a woman's fundamental right to medical autonomy. The court was particularly critical of the lack of evidence provided by the state to justify such a sweeping restriction. In legal terms, the state could not prove that these abortion laws constituted reasonable and necessary restrictions on the rights of pregnant women. This wasn't just a disagreement over policy, it was a failure of legal craftsmanship by the MAGA-led legislature, which failed to build a record strong enough to withstand the scrutiny they knew was coming. This failure has massive implications for future legislation in the state. By setting the bar at strict scrutiny, the court has made it nearly impossible for the legislature to simply repass the same ban with different wording. Any future attempt to limit reproductive rights in Wyoming will now have to navigate a legal minefield where the individual's right to health care is the default starting point. The ruling sends a clear message to political actors. When you touch a fundamental right, you better have an airtight case. In Wyoming, the state came to court with a political mandate, but lacked the constitutional evidence to back it up. For a 4-to-1 majority, the principle of individual liberty outweighed the state's desire for total control, effectively proving that even in a deep red state, the judiciary can be the final barrier against legislative overreach. The 4-to-1 split on the Wyoming Supreme Court was a clear demonstration of a judiciary asserting its independence from the executive and legislative branches. The majority opinion was formed by Chief Justice Baumgarten, along with Justices Kate Fox, Robert Jaros, and John Fenn. Together, they formed a coalition that prioritized constitutional text over political ideology, effectively signaling that the court would not be a mere rubber stamp for the MAGA-led legislature's social agenda. Chief Justice Baumgarten's writing was particularly direct in its refusal to yield to legislative definitions. The court explicitly rejected the state's argument that it should defer to the legislature's finding that abortion is not health care. By doing so, the majority established a significant legal boundary. Politicians do not have the authority to redefine medical terms to bypass constitutional protections. The court asserted its own power to determine what constitutes health care under Article 1, Section 38, rather than allowing the Life Act to dictate the terms. The majority's reasoning highlighted the deep, multifaceted nature of medical decisions. They argued that a woman's choice to continue or terminate a pregnancy is influenced by an array of personal factors, including physical and mental health, financial status, career plans, and even religious beliefs. By acknowledging these factors, the court painted a picture of health care that is fundamentally individual and private, rather than a matter of state policy. They concluded that although the decision ends fetal life, it remains a healthcare decision made by the woman regarding her own body. On the other side of the bench sat Justice Carrie Gray, the lone dissenting voice. While her specific written dissent follows traditional conservative judicial lines, it aligns with the disbelief shared by Republican leaders like Speaker Chip Neiman. Neiman's reaction, questioning who speaks for the unborn human beings and accusing the court of rejecting basic biology, represents the ideological perspective that Justice Gray's dissent likely mirrored. For the dissent, the focus remained on the rights of the fetus rather than the constitutional autonomy of the mother. This 4-to-1 divide exposes the internal friction within Wyoming's institutional leadership. The majority effectively acted as a constitutional wall, protecting individual medical choices from being engulfed by the state's partisan shift. Meanwhile, the dissent and its supporters in the Freedom Caucus continue to view the ruling as a dark day that ignores their version of human dignity. This tension on the bench ensures that the court remains the ultimate arena where the battle between legislative power and individual rights will be decided in the years to come. The fallout in Cheyenne was instantaneous and vitriolic. Speaker of the House Chip Neiman, a Republican from Hulett County, became the face of the institutional backlash, expressing total disbelief that his legislature's work had been dismantled by the state's highest court. To Neiman and his allies, this wasn't just a legal disagreement, it was a moral catastrophe. He publicly questioned why little unborn human beings were not being afforded rights, even suggesting they should be counted in the census and allowed to vote. This rhetoric underscores the deep ideological divide between the legislative branch, which sees abortion through a lens of biology and human dignity, and the judicial branch, which views it as a matter of constitutional healthcare autonomy. The Wyoming Freedom Caucus took the rhetoric even further, declaring the ruling a dark day in Wyoming history. Their statement was a direct attack on the judiciary's legitimacy, accusing the Supreme Court of being filled with jurists who reject basic biology, after decades of what they termed liberal leadership in the governor's office. This is a significant escalation. By attacking the court's competence and bias, the Freedom Caucus is signaling that they no longer view the Wyoming Supreme Court as a neutral arbiter, but as a political enemy. This erosion of trust between the branches of government is a classic hallmark of a constitutional crisis in the making. For the broader Republican Party in Wyoming, the ruling has created an impossible choice. They are geo-trapped between a base that demands total abolition of abortion and a state constitution that, thanks to their own 2012 amendment, protects medical choice. GOP senators and representatives are now facing immense pressure to find an exit ramp or a way to override the court. However, With a 4-to-1 majority on the bench and a clearly defined constitutional right, their legislative options are severely limited. They must decide whether to stay the course with their current leadership or stay with the alliance of the broader democratic system. The social reaction has been equally polarized. While advocates for reproductive rights celebrated the restoration of what they call first-class citizenship, the state's conservative establishment is warning of a shaken relationship between the people and their government. This ruling has effectively turned Wyoming into a legal island, where the state's highest court has stood firm against the national MAGA trend of total bans. The fallout isn't just about abortion, it's about who truly holds the ultimate power in Wyoming, the voters who pass amendments or the legislators who try to interpret them. As the dust settles on this initial explosion of anger, the question shifts from what happened to what happens next. The Freedom Caucus and their allies are already signaling a long-term campaign to reshape the court through retention elections. They are betting that the public's anger over this specific ruling will outweigh the state's traditional respect for judicial independence. In the halls of power in Cheyenne, the tension is palpable as a deep red state prepares for a potential civil war between its own institutions. The Wyoming decision is not an isolated event, but part of a calculated national trend that has emerged since the federal protections of Roe v. Wade were dismantled. Since the U.S. Supreme Court's Dobbs decision ripped away a 50-year-old constitutional right, leaving the issue to the states, the battleground for reproductive rights has shifted entirely to state-level judiciaries. We currently see a country divided, where half the states face near-total bans, and the other half sees a fierce defense of reproductive autonomy, creating a fragmented reality where a woman's status as a first-class citizen depends entirely on the state in which she resides. This Wyoming ruling demonstrates that advocates are no longer just reacting. They are strategically utilizing state constitutions to build a new legal floor for individual rights. We are seeing this pattern replicate across the country, from the Midwest to the Rocky Mountains. In states like Wisconsin and now Wyoming, reproductive rights advocates have successfully pivoted from federal litigation to a dual-track strategy, lobbying state legislatures while simultaneously winning critical battles in state Supreme Courts. By identifying specific, often overlooked state constitutional provisions, such as Wyoming's 2012 Medical Choice Amendment, they are forcing state judiciaries to choose between partisan social agendas and the literal text of their own state laws. This strategy has turned state courts into the most effective barriers against legislative overreach in the MAGA era. The focus is now moving aggressively toward the ballot box, specifically targeting judicial seats. State Supreme Court justices are increasingly becoming the central figures in political midterms and general elections. Whether a court is officially nonpartisan or explicitly partisan, the ideological makeup of these benches now determines the ultimate limit of legislative power. In many states, justices are currently up for grabs or running for retention, and these individual judicial seats have become the most significant gatekeepers of constitutional liberty in the post-Roe landscape. This state-by-state resistance effectively challenges the national MAGA narrative that the Dobbs decision was a final conclusion. Instead, it was the starting gun for a marathon of institutional conflicts. Advocates have figured out how to work the legislatures and win in the state Supreme Courts by making the case that reproductive rights are inseparable from broader healthcare and privacy rights. Wyoming has now provided a powerful template for how even a deep red judiciary can be persuaded to uphold individual autonomy when presented with a clear constitutional mandate. As we look toward the upcoming midterms and the 2028 elections, the Wyoming ruling stands as a glorious day for those who advocate for equal citizenship. It serves as a stark reminder that the judicial system can still act as a robust check on legislative overreach when individuals are empowered by their own state's constitutional text. The fight has transitioned from a single national debate into 50 distinct legal wars, and Wyoming's decision proves that for reproductive rights advocates, the state-level strategy is not just a defensive posture, it is a path to victory. The Wyoming ruling marks a definitive shift in the American legal landscape, signaling that the next decade of political conflict will be fought not in the halls of Congress, but in the deliberation rooms of state Supreme Courts. As we look toward the 2028 elections, the focus for both reproductive rights advocates and MAGA strategists has moved to the judicial seats that are increasingly up for grabs across the country. This is no longer just about passing laws. It is about who has the final authority to interpret the state constitutions that have become the ultimate battlegrounds for individual liberty. In many states, these justices are directly elected by the people, offering a rare opportunity for voters to have their voices heard on the composition of the judiciary. Moving forward, every judicial candidate will be scrutinized to determine if they are aligned with the MAGA movement, the Republican Party, or the Trump platform. This transparency is essential because, as the Wyoming case proves, the ideological leanings of a few justices can determine whether a woman remains a first-class citizen or sees her rights stripped away by legislative decree. The restoration of equality in Wyoming serves as a glorious day for those who believe that reproductive rights are fundamental to a free society. However, the institutional fallout remains intense, with the Wyoming Freedom Caucus and other conservative groups already preparing to challenge the court's legitimacy in upcoming retention elections. This creates a high-stakes environment where the judiciary must navigate a path between upholding the law and surviving a highly polarized political climate. To truly understand the gravity of this unbelievable verdict, one must look beyond the headlines and into the actual 70-page decision that defines the current limits of state power. By analyzing the oral arguments and court filings, as shared by legal analysts like George Williams, it becomes clear that the fight for constitutional integrity requires a deep engagement with the legal mechanics of our system. This is the only way to ensure that checks and balances remain more than just a theoretical concept in deep red and deep blue states alike. Ultimately, Wyoming has shown that even in a political environment saturated with partisan rhetoric, the literal text of a state constitution can still provide a definitive shield for individual autonomy. The unbelievable verdict is a testament to the fact that American power is at its best when it protects the rights of its citizens from the overreach of its leaders. As we head into the next election cycle, the Wyoming Supreme Court has set a precedent that will resonate far beyond the borders of the equality state, shaping the future of democracy for years to come.